Welcome everybody to the latest webinar in the series co-sponsored by the Ecological Law and Governance Association, and in this case, the Leadership for the Ecozoic Project, which is part of McGill University and the University of Vermont. We have in store for you today a really rich topic, one that I have been looking forward to bringing to this webinar series, and especially to bringing to this series voices from the community of Indigenous people who have firsthand experience with Indigenous law and Indigenous legal traditions. We are very fortunate today to have Kirsten Anker, who teaches at the McGill Faculty of Law and has a rich scholarship around Indigenous legal traditions and Indigenous law, to lead the discussion and share the discussion. And two presenters, Shiri Pasternak, who's the research director at the Yellowhead Institute and assistant professor in criminology at Ryerson University, and Rayanna Seymour, who is a lawyer with the West Coast Environmental Law. I'm really lucky to have them with us today. Before I turn this over to Kirsten, I just want to draw everybody's attention to this webinar series in general, and to let you know that our next one will take place on October 21st at the same time as today, 3:30 in the afternoon. The seminar, that webinar will be probably something more like a conversations about race and ecological law, and not just racial ecology. But I invite you all to keep track of that. We'll be posting information as we get closer to the date. With that, I will turn things over to Kirsten. And Kirsten and Shiri and Rayanna, you can unmute yourselves.
So, hi everyone, bonjour, Kwegwe, Sego, Tansi, bonjour. My name is Kirsten. I'm a professor here at Montreal at McGill University, and I'm here on Tiohtià:ke, the unceded territories of land that has been cared for by the Haudenosaunee and Anishinaabe peoples for a very long time, and it's long been a meeting place for all kinds of peoples. And I also want to acknowledge that this webinar is coming on the heels of 2 days of online teach-ins organized by the people behind the scholars strike, dealing with the issues of systemic violence that affect Black, Indigenous, and other racialized peoples. And that's part of the conversation that I want to use as the context. Well, what I want to use as part of the context for the conversation today. So there's often references to Indigenous practices and ways of thinking in ecological law scholarship, and there's a lot of resonance between Indigenous ways of thinking and the principles of ecological law. So, scientific principles or scientific understandings of integrated and interdependent ecological systems has pushed us to think holistically about governance. There's been an ethical push within ecological law to decenter the human, so that we recognize the intrinsic value of all things. The goal of ecological law should be the mutual thriving of all beings, and human law should be derived from the laws of nature and respect for the inherent properties of the earth necessary to sustain life. From the Indigenous side, common themes are the idea that everything is alive or everything has spirit, that non-humans also have personhood and agency, and indeed humans have kinship relationships with them, that the land is the source of the law. So there's a number of resonances between ecological law and Indigenous legal traditions. And of course, this is not an accident. A lot of the key figures in the early environmental movement in North America that then grew into the ecological law movement have been deeply influenced by Indigenous philosophies, have worked in partnership with Indigenous communities, and some of the key initiatives in ecological law. Many of you will be familiar with the idea of the rights of nature or legal personhood for natural entities, of course, have been sort of largely spearheaded in many places like South America or New Zealand by Indigenous peoples themselves. So there's a lot to talk about. I think there's a lot of possibility for rich conversation between these two movements. So my objective is to try and host parts of that conversation today, but also to engage with, so it's not just an engagement with Indigenous knowledge, but also the larger project that our two guests today have been involved with. So thinking through Indigenous law revitalization, Indigenous rights, self-determination and jurisdiction, and of course the colonial and neo-colonial contexts in which this movement is operating. So I'm going to start by, I didn't ask for presentations from our speakers. I kind of had the idea of hosting a more fluid conversation, but I will get them to both present the work that they do so that you can have a sense of where they're coming from and some of the really amazing projects that they're involved with. So Rayanna, would you like to start off?
Sure. And just to be clear, starting with my presentation or just introducing myself? Oh, you're on mute.
Yeah, if you can start with your presentation, that would be great. Yeah, so we can have an idea of your work.
Okay. How do I do this again? All right. So, hello, bonjour. My Indigenous Jean Kutuk Indigenous Cause Makwan Dutem Neongashin Dunji. My English name is Rayanna Seymour. I'm a staff lawyer at West Coast Environmental Law, but I'm also the RE-Law manager. And RE-Law stands for Revitalizing Indigenous Law for Land, Air, and Water. At West Coast Environmental Law, we're a not-for-profit legal organization. So the clients that we have, or the partners we call them, we support in securing funding for our partnerships, and I'll get a little bit more into what I mean by partnerships. So yeah, we're a group of strategists, lawyers, and legal thinkers, and a communications team looking towards transforming the legal landscape. So our organization is very intersectional. There are different departments, the RE-Law department, there's the Marine department, development, and we have lawyers that work in on the provincial level and the federal level, among a lot of other, work that our lawyers do. So that's kind of a sense of West Coast Environmental Law. We work specifically with BC matters. So West Coast has been working with Indigenous peoples for decades. And it was through, working with Indigenous law and collaboration with Indigenous nations over the last few decades that spearheaded the work for the RE-Law program. So RE-Law was established in 2016, but West Coast has been working with Indigenous nations much more before that. And I'll get more into what the RE-Law methodology and all of that too in a little while. So I wanted to start off with kind of just introducing myself and sharing a little bit of my story. So, and how I came to this work and this job at this point in time. So I grew up in ceremony and POW and in community. My mom took me to all of these gatherings, and I was learning our processes, our protocols, our stories, and things like that. Like, that was just natural to me. But then also living within, Canada, going to school and dealing with racism and all those things in a small little town. So when I was in my late teens, I started really focusing on understanding who I am as an Anishinaabe Kwe, as an Anishinaabe person, as an Anishinaabe woman. And that's when I began to find my voice. So I was part of decision-making tables as a youth representative starting in my late teens, and that's what inspired me to pursue law, because I met, you know, chiefs, and our Grand Chief at the time was the first female Grand Chief, and she had a law degree. So her expertise came from understanding Canadian law, but also Anishinaabe law. And I thought that was so powerful because she was able to sit at a decision-making table and bring both of those perspectives forward. So that's what completely inspired me to pursue law. And yeah, so I was at decision-making tables with youth leaders, chiefs, politicians, communities, and just really listening, you know, building that knowledge and understanding where we come from as a people and dealing with these issues. Because you know, there's so much issues that we deal with. And so it was very, you know, powerful for me to experience that. And so basically, you know, like my experience is not only my education, but it's lifelong lived experience in lodges, in community, with elders, and that work continues today in just a different way as a re-lawyer. So we call ourselves re-lawyers. So basically my whole life I was experiencing on the land learning and, you know, in the room learning with our decision makers and things like that. And, you know, I often really, really loved hearing the stories. That's when all the time my ears would perk up. So when elders would start talking about trickster stories or origination stories or how things came to be how they are, there's always an answer to why things are the way they are physically on the landscape, but also, you know, just how we act. There's often stories that explain those things, right? So whenever there were stories that came up, I was always listening, and I was particularly interested in Nana Buju stories or Nana Bush. And Nana Bush is this being in our stories. He's known as the original man, but they're also a trickster. So, you know, Nana Bush or Nana Buju taught us so much about, you know, they prepared the land for us to come basically before the humans came. So they went around all of the territories, naming the territory, getting to know the different beings that are on the territory, and talking with them, ensuring that they're ready for us. So then that's when a lot of the beings stood up and said, I'll sacrifice myself for our relatives to survive. And that started with the deer and the caribou and the moose. So, you know, there's that relationship goes back way, way back in time. And these stories, although they might seem, you know, romanticized, or they might seem like they're only in the past, I'll explain a little bit why I think that's untrue. So, when we understand that, you know, there's stories on the land, and it gives us a different lens, or it offers more perspective to actually view the land as living entity, or that the land has spirit, as Kirsten was saying. So when you hear these concepts, it might be hard to understand at first, but if you go deeper into it, you'll start to understand why we say those things as Indigenous peoples. So I was talking about Nana Bush and Nana Buju, right? That being that was here before us, that set the land how it was today, and set the processes and encouraged all the beings to get ready for our arrival. And Nana Bush laid down to rest here. And this is known as the sleeping giant in Thunder Bay. So Nana Bush lays to rest in Lake Superior. So there's so much stories like this that, you know, are on the land and that can support us in understanding, you know, deeper on why the land is so significant, and understanding why Indigenous peoples are so intrinsically connected to the land, because ultimately, like, we come from the land, and what happens to the land happens to us. And I'm sure, like, you've heard that type of concept as well, you know, in mainstream media, but there's just so much behind what those mean, and the English language is unable to capture exactly what we mean. So, you know, we're also working with an English language, so that's another, you know, it's a challenge at times. So, you know, having a sense of the importance of story, you know, what is Indigenous law? There are lots of answers to this. It's all interconnected, but the RELAW approach is really, you know, that law is an active and collaborative process. At its most basic level, law is collaborative problem solving and decision making through public institutions with legal processes and of reason and deliberation. So, you know, it's said through sustained engagement with law that people create the necessary intellectual space to critically examine norms, power, and assumptions. A healthy exercise of agency and citizenship, so integral to healthy societies. So this is very much our approach as the RELAW team to engaging with community, and it's really about deliberative process, us sitting together with them, talking about story, talking about strategy, and talking about visions for the future and, you know, how to implement those visions. And actually, there's a lot of issues that come up with in deliberation, in dialogue, right? So such as gender roles. So you heard me talking about Nana Boozhoo as a he, but what if we switched the pronouns and talked about Nana Boozhoo as a she? And that's exactly how Val Napoleon approaches her work too with, so in her legal tradition, the trickster is the raven. And in all of the stories that she's heard, raven is always a male. But then in her lens and perspective of the raven, the trickster is a grandmother who teaches law. So, you know, different ways to kind of look at our stories and think about, you know, and explore, you know, challenges or concerns or just really whatever is happening. It's all about deliberation and dialogue. So we kind of, you know, deal with things as they come up. So basically, if you're wanting to like understand more what Indigenous law is, there are many different ways that this can be achieved. But really, like Indigenous law is law, and we understand that at West Coast Environmental Law. It's a process, you know, it's expressions of worldview. Their illegal traditions are specific to those Indigenous peoples. That's very much land-based and, you know, local, or regional. And there are many sources. Can come from custom, song, stories, language, or ceremonies. But really, like Indigenous law is about our relationship to land, spirit, water, and other beings. So take this piece of art, for example. It's the perspective of Danielle Morrison. She's an Anishinaabe Kwe, about our Anishinaabe Nibenakanagewan. So that's our water law. And you can see so much in that picture, the interconnections, intergenerational knowledge exchange, spirit, you know, different beings, birds, fish, plants, life, really, you know, that's kind of like, yeah, what our laws tell us in Anishinaabe, is that we're all connected. So becoming an expert in Indigenous law or a specific legal tradition such as Anishinaabe law, you know, it takes time and it takes persistence. I've met elders who I would consider experts who would not consider themselves experts. You know, I often hear elders talk about from what little I know, but they know so much. So it's like really interesting witnessing the humility with holding these teachings. There's very limited hierarchy, right? So yeah, you hear these concepts again, like living in harmony or living in peace, living in a web, all my relations. Like these are very short form English concepts of you know, an understanding or a worldview. So there's this concept in my language called Nindina Wimaganatuk. And what that means in English is all my relations. But what that really means in my language is I acknowledge all of my relations that are here today. Not just human, not just blood, but like, you know, the beings that I can't see, or the animals outside, you know, the land itself, the water itself. Like, I'm acknowledging everyone and everything when I say that. So, you know, Indigenous law offer just like, I guess, more big picture thinking about issues, and allows more imagination into coming up with strategies to solve those issues. And, you know, often it takes like distinguishing between what perspective you might be coming from. So often I talk about, well, I'm taking off my lawyer hat and I'm putting on, you know, my Anishinaabe lens hat, you know, and sometimes I might have two perspectives on a certain thing, like, or maybe those perspectives are like bleeding together. But like recognizing where my perspective is coming from is really important, because often the Western ideology is very linear. And this goes back to this concept of story too. So like in middle school, we were taught a story is very linear. It has a beginning, it has a climax and a plot, and it has an end. But for Indigenous stories, it's very cyclical, just like how we view life, very cyclical. So often with one story, there's not a beginning, middle, and end. It's often part of another story that goes into another story. So one story is probably part of this massive story. So, you know, the process of even reading stories and discussing stories has to be kind of unpacked and thought about of where, you know, those thoughts are coming from. So, you know, implementing these types of understandings into our process within the RELAW team has been an ongoing learning journey. And I think we get better every year. Because again, like the law is a process, right? Decision-making processes or deliberative processes. And this is really what our entire work is based off of. So, you know, we are environmental lawyers, but we look not just at environmental law. Environmental law is one tool in the toolkit. You know, we really focus on, you know, collaborative decision-making and getting rid of the siloed approaches. So streamlining, you know, our work and building our network with supporters and things like that. Like it's all part of, you know, the big picture. So yeah, environmental law is a part, supports in that Indigenous law revitalization and recognition. So the power of stories offer us a glimpse into the past to inform our present and plan for the future. So maybe the problem with, like one of the problems with environmental law is it often is, you know, like a niche problem. So like say there's water quality issues in this area, for example, but like with the Indigenous law or RELAW approach, we look at more like the nation level. So how big is that territory? It's not specific to one, you know, area of that territory, but it's more, I guess, regional based. So it's more local and regional decision-making processes that we, you know, we look to, and sitting down with decision makers. So if that's chiefs and elders, and supporting with, you know, facilitating those discussions. So yeah, with story, there's so much stories that talk about wildfires and droughts and famines and floods and scarcity issues, you know, and today we're facing all of these. So these stories have a lot to offer to understand how people's dealt with those issues in the past and how they got past those issues. What was their process in figuring out how to handle this problem, whether it was immediate or whether it was further out into the future. And then starting from these stories, it provides, you know, it provides more space for imagination, because the problem with, you know, colonial or Canadian law and policy, it kind of prevents reimagining better futures where there's an abundance of species, because it doesn't really think about long-term future, right? But with Indigenous law, and the work we do with that and our work with stories, we try and, you know, really make space and encourage active dialogue and dealing with those issues then. So, yeah, so working with stories supports us in being proactive instead of reactionary, and looking backwards, but then also forward. And instead of command and control legal decision making, which is often, you know, the process of environmental law, we go to the roots of the legal system as a whole, and the social context and political context of, you know, that's happening during that time. And I think it's just helpful to point out about like what's happening in the world right now. So we see fires in California, and then there's news articles going around about how tribes use their own, you know, fires to be proactive, to discourage wildfires. And now mainstream media is starting to realize like that they understood what they were doing. So there's a lot of these types of examples coming up where mainstream organizations or governments are recognizing that like Indigenous peoples know what they are talking about, and they have solutions to our problems. But then I think there's a delicate balance too, because it's like there's a lot of loss and a lot of revitalization work that has to happen, because colonization has, you know, impacted everything about us. So there's a delicate balance to understanding that there's a lot of knowledge there, but there's also a lot of loss and emotion surrounding that. So just to give a sense of like sources of law, Professor John Burroughs describes 5 sources of law: deliberative, positivistic, natural, sacred, and customary. So you heard me talk about deliberative. That's the one we really focus on within the RE-Law. So that's having dialogue, and, you know, there's a lot of planning behind that with the lawyers on like, what's the process going to be? What questions do we ask? And, you know, who needs to be in the room and all those things. And with that partner that we have, where the nation that we're partnered with, kind of look to how their own stories could guide us in that process. So beginning with story always. Yeah, and sacred has to do with spirit. So you heard me talk about the land has spirit. But, you know, most notably, I guess an example of sacred law is the numbered treaties in Canada. So often, most of the numbered treaties followed Indigenous law and protocol. So that's why we, like a lot of Indigenous peoples and a lot of allies, focus on the spirit and intent of the treaty, not the actual treaty document, because from Anishinaabe or Indigenous perspective, I'll speak for Treaty 3, but like we did not surrender our land. We agreed to share it in exchange for certain promises, but on the document it says that we ceded and surrendered. So like we focus on that spirit and intent of the treaty. right? That's an example of sacred law. Natural law is learning from the land and water itself. So take the example in New Zealand, or Aotearoa, for example, that Kirsten acknowledged, where legal personality was sought for decades, or even like, yeah, many, many decades, for the legal personality of the Wanganui River, which was finally recognized by New Zealand common law just a few years ago. Positivistic law is more because I said so, or it's written in stone. So this could be like legislation, or in community, it could be just listening to an auntie because she said so. And customary law is just the way things are done over time. So the RELAW approach, I kind of went over this a little bit, but as lawyers, we learn from stories and elders. We call this doing our homework. So even before we engage with community and knowledge holders, we already read and discussed maybe like dozens to 100 to 200 stories. So like a lot of, you know, case briefing. So what are the facts of the story? What are the teachings in that story? And how did that, what was the process in reaching that decision, for example? So, you know, we already begin our research before even coming into community. So we have a little glimpse into that legal tradition. And then we start community deliberation with knowledge holders, and then later on with decision makers. So, you know, and then throughout that process, the lawyers are drafting a legal synthesis, so putting all of this information together. And then from that legal synthesis, we go back to the decision makers, and we decide what we're going to do with all of that information. So if they want to create an Indigenous law instrument, whether that's an act or a declaration or some sort of instrument to kind of articulate those laws and principles within that legal synthesis. And then, you know, on that matter, what they're dealing with, whether it's fisheries governance, watershed management, restoration, you know, things like that. And then we look into implementing, enforcing that Indigenous law instrument on the issue that they're trying to deal with. So often these processes blend in together, and sometimes we don't know we're into the next part until we're actually there. So, you know, it's very fluid. So that's why it's in a circle. So just personally, at West Coast Environmental Law, we are empowered to share our perspectives and our unique lens to the law and legal landscape. And as a staff lawyer and articled student, I was very empowered and had support through the RELAW team and beyond at West Coast to use my voice and to implement my plans and things like that. So I really appreciate being able to take an intersectional approach to this work, and that it is not for profit. I found that during the pandemic, we really started to think about it at an organizational level about the climate of today. So dealing with these pandemics of racial injustice and COVID-19, what does this mean for West Coast, and how can we make our organization better, right? So yeah, we have continued discussions about this and are looking into different ways to, you know, ensure growth of our organization. And the RELAW program, so these are like our partners, we call them. So we, you know, enter into a partnership with an Indigenous nation, and they already have they almost always have like a clear sense of the issue that they want to tackle and have a sense of like an idea of what they want to do. So we have discussions with them to see if it's a right fit for both of us. And then we begin in this, you know, co-learning program. So the co-learning program is a year long, and really it's about encouraging capacity in Indigenous law revitalization in community. So sometimes we're able to offer grants to support, you know, community hiring. And there's a lot of, you know, planning behind the scenes that goes into us as lawyers getting together the tools available for strategizing, but also just the process of the co-learning experience. So how we've done it every year is having 3 major in-person retreats, focusing on the research, focusing on the application of that research, and then the implementation and enforcement of that Indigenous law instrument, if that's what they create. So yeah, partnerships often last years. And yeah, it's really about co-learning and encouraging connections between our partners, so they could support each other in their revitalization works as well. So it's not always us who have to be that middle person. So I've kind of already said this, but the role of re-lawyers is working. So the research with stories, facilitating dialogue with elders, knowledge holders about Indigenous law and stories, supporting capacity building, such as the ReLaw's co-learning program, strategizing with decision makers on courses of action. So like we need to understand what's happening in Canadian law, what tools we have there, what are the cases saying, things like that, and collaborating with others. So streamlining works with other organizations and things like that, because we know within Canadian law, there's so much siloed works being done with so much people doing similar work but not communicating. Yeah, so the role of the re-lawyer has many faces to it. And, you know, a big part of that job is drafting of Indigenous legal instruments. So, you know, one example is the assessment of the Trans Mountain Pipeline and Tanker expansion proposal. We didn't create this whole document, but there's a chapter in there on the Indigenous legal traditions that was drafted by our team. So this is an example of an Indigenous law legal instrument used for enforcement. So, you know, the Tsleil-Waututh Nation used their own assessment of the proposed Trans Mountain Pipeline and Tankers project as a matter of their own laws. And under their own laws and under scientific study, they said no to the Trans Mountain expansion project. And they have used a variety of strategies, including litigation, financial pressure, building allies to enforce their decision to reject the project. So yeah, we have like a really talented lawyer, Eugene Kung, who works very closely with them and who is involved in all of these discussions with Tsleil-Waututh and with other, you know, experts. So with this work, there's another one being made too within our team called, it's based out of Heiltsuk territory, and they're creating an ocean, taking care of our oceans and relatives act as an Indigenous legal instrument. So, you know, and they're really powerful people too, because I like sharing an example of enforcement for them. So there was crab, you know, population decimating in their bay. So they started enforcing their own laws to tell commercial fishermen to leave out of their bays because the crab were endangered. And then, so they were out on the water every day, you know, protecting their water. And then the crab population started to increase almost immediately. And then the Department of Fisheries and Oceans realized like, oh, like they know what they're doing, and then started recognizing that authority to, you know, to tell people to leave their bay. So yeah, there are many examples, but I think the process of, you know, working with Indigenous nations and working with stories and law, we have to be up, we have to ensure we're trained in the trauma-informed approach. So we receive training of, like in the co-learning sessions every year, the whole ReLaw team, but also our partners. So we recognize and prepare for trauma resurfacing in focus groups, retreats, in person, and now online. So, you know, we do a lot of thinking and planning ahead. So who are we meeting with? What is the space we are meeting in? How do we encourage agency for the participants? What is our intent of this, you know, gathering? So ensuring that people feel free, that they're not stuck, that they're able to share their perspectives, and that everybody's voice matters is really integral to, you know, our process and meeting in community. So that was kind of a snapshot into my work, West Coast environmental law, and the process that we take through deliberation with the Read Law team and with our allies and with our co-learners. So thank you so much.
Thanks so much, Rayanna. Look, there's two things that you raised that I'll come back to later in the discussion, but I just wanted to flag them now. And one is, you know, I think because those of us who are academics and trained in legal fields and other fields, we often tend to approach the ecological bases of law or an engagement with Indigenous law in a really intellectualized fashion. And I think you're pointing to stories and art and so on, and I know ceremony is also a big part of it, points to a more fulsome way of engaging with relationships with the earth rather than just everything happening in our mind. The other thing you just raised briefly at the end was the role that dealing with trauma has in the processes that you use to work with community members. And you know, I hope that's something that we're going to be talking about more with the conversation with Shiri about the colonial context in general. But I think trauma more broadly is something that you know, a lot of us are dealing with in contemplating what is happening around the world, and you know, the sort of psychosocial aspects of climate change are something that should be part of legal processes as well. So I'd like to invite Shiri now to talk to us about her work at the Yellowhead Institute.
Hi, can you hear me okay? Thank you. Thank you to Kirsten for inviting me, and to Jeffrey as well. And thank you to Rayanna for that presentation. It was just phenomenal and I learned so much. It was maybe the clearest presentation I've ever seen on Indigenous law. And I thought I knew what West Coast environmental law did, but I have such a deeper sense of the care and the thoughtfulness that you put into the work, especially as Kirsten was mentioning the idea of how much sort of trauma informed your practices and how that becomes internalized through a reflexive process within the organization. That's maybe one of the most beautiful embodiments of Indigenous law I've seen in an organization, since it really treats you know, these really complex problems of the encounters of colonization with Indigenous law really carefully as really sensitive and delicate issues that raise a lot of pain from the histories of how those laws have been attempted to be taken away or devalued. So I just learned so much. I just want to thank you for that incredible presentation. I feel like I'm kind of like Bad News Bear now with my presentation, talking about the Yellowhead Institute, particularly my work within it. Jeffrey just identified me as Indigenous, and I just want to clear up right away that I'm actually one of two non-Indigenous people in the Yellowhead Institute. I'm the research director and the co-founder. And I really see my role as being about, as a first generation Canadian, as holding my own government to account, and also really doing sort of harm reduction in confronting those very violent structures of colonization in order to protect people who are doing that really important reclamation work and sitting by the fire and making that fire grow. And by fire, I mean literally fire, but also in terms of Indigenous knowledge and practices and law and governance that is being restored. right now. And so I'm going to talk a little bit about my contributions to the Land Back report that I believe was one of the readings for the week. And sorry, I have a bit of a cough. I'll start by introducing myself more personally. So I do work at Ryerson University, and I do come to this work too through a family relation, through my best friend who was growing up is Indigenous, and her stepfather, Russell Daibo, sort of took me under his wing when I was in my early 20s, and he mentored me and introduced me to his best friend, the late great leader, Arthur Manuel, Secwepemc leader. And I worked with them for many years in the Defenders of the Land Network, Barrier Lake Solidarity, in Toronto solidarity groups like the Indigenous Sovereignty and Solidarity Network. And so I have spent 2 decades working on the ground with communities who are who don't recognize the history of Canada to be one of dispossession, but as an attack on their jurisdiction. So people who do not consider their lands to be stolen, but consider the theft to be that they can't exercise their governance and their laws on the lands that they know to be theirs. So I always try to say that because I teach courses on Indigenous governance and justice. Really, I teach about the history of colonization. That's the perspective that I feel comfortable taking. And sometimes students get really upset and they're like, Canada, when they stole everything and they really did so much violence and there's nothing left. And I'm like, no, I'm not saying that. I never said that. The whole point is to understand the violence of the structures of Canadian law as being a reaction to the strength of Indigenous law. There's no need for violence and repression and subjugation if there's no resistance. And so really flipping that story and teaching that story from another perspective. And so that brings me to Land Back, and I'll get back to my provocative title here. But Land Back is the first red paper of the Yellowhead Institute. Once a year, we want to put out a marquee research project that brings together a coalition of voices from across the country to focus on a particular issue and to parse out what is critical for communities on the ground to learn, to know, and to understand. And so we brought a group of people together. And speaking about trauma-informed approaches, we thought we were going to talk about the political economy of Canadian colonization, and we went around in a circle to talk about how people wanted to talk about issues of consent on Indigenous land. And the consensus was clear by the time we went around the circle that people really felt like you can't talk about colonization, can't talk about land without talking about gender and without talking about the role of women and the way that's been displaced, both internally within communities and externally in terms of the structures of Canadian legislation, policy, and law. And so that really shaped the way that we wrote Land Back and thought about it. So the beginning of the Land Back report focuses on the idea of crown land. And so that's where I want to start. And I'm not going to talk for too long. I just want to hit on a few points about intersections between Canadian law and Indigenous law, and where the kind of really sort of violent screeching is taking place from the perspective of what Canada is doing in order to try to really minimize any other ways of understanding human, non-human relations, or understanding Indigenous laws as not just being sort of cultural laws, but about being grounded in alternative economies, grounded in family structures, grounded in a different form of nationhood than modern statehood. So the red paper begins with Canada claiming 89% of the land base in this country as public land or crown lands, both provincial and federal. And really, I feel like in order to really understand why Canadian law is so violent against Indigenous law, you really need to understand Canada as a bad company, as a colony that was fundamentally set up as a fur warehouse for Europe, and that gained probably the largest portion of its land base through the sale of Hudson Bay Company back to Canada in 1868. So this country was a company before it was a country. About a third of the land base was Rupert's land, which was a gift from the King of England to his cousin Rupert. And it was the entire drainage basin of the Hudson Bay Company. And so when we think about what is the source of Canadian law, what is the source of settler colonial law, it's both the law that was patriated from England that became the parliamentary system that we adopted, and the case law that we adopted, and the high court that we still referred to in the early days. But it was also generated out of the political economy of colonization and resource extraction. So Hudson Bay Company in their original royal grant had magisterial powers. They could make laws. And so did the Indian Act agents, so did the Northwest Mounted Police, and so did the Hudson Bay Company. And so when you look at where law came from, it came in relationship to the need to erase or override the Indigenous legal systems that were being asserted against the preying and encroachment of settlers on Indigenous lands. And so when we look at sort of natural resource regulation in this country, we can't just look at them as neutral regulatory frameworks. We have to understand them as fundamentally colonial, as fundamentally generated out of a need to claim jurisdiction over the assertions of jurisdiction of Indigenous people. And the way that the Canadian economy developed and the political system developed went hand in hand with the economic imperatives of the state. And so that's why, you know, when I started doing research for the land back paper, there were a few things I really wanted to focus on to expose the way that the state really used legal tools in order to deny Indigenous forms of value attributed to land. And one place that you see this most clearly is around injunctions. And it was sort of anecdotal, and it was a hunch when I started doing this research with a group of researchers at Yellowhead, which was that it just seemed like every time a company wanted to get First Nations off the land, they would just file an injunction, and they seemed to always get it, and provinces as well. But I was not expecting the level of discrepancy between First Nations attempting to get injunctions against corporations and governments, and the rate of denial there versus the rate of success when corporations and governments tried to get injunctions to remove Indigenous people from their land. And there's a lot that could be said about this, but I just want to parse out one thing, which is one of the tests to get an injunction, as many of you will know, is the balance of convenience and irreparable harm. These tests to show who is more injured, you know, if the party is not removed from obstructing a project. And when we looked at over 100 cases, and you could see over and over and over again, companies would say, we aim to lose $100 million, $200 million. None of this is ever fact checked by the court. By the way, it's just the claim being made. Indigenous people would say, look, this is an important cultural site. This is a cemetery. This is a moose den. This is a fish spawning site. This is a sacred area. Those forms of value, those economies, those forms of law, those systems of governance are not legible within the court system. And so this rinky-dinky injunction tool overrides not only Indigenous law, but also a whole jurisprudence, however problematic, of Aboriginal rights and title, which don't come into the court in these cases. And so this is an example of where you really see the structure of the legal system really built around the protection of private property. We also looked at impact and benefit agreements, which is another form of law, you know, that's problematic in a way that's captured in the headline. Why are Indigenous rights being defined by an energy corporation? So an impact benefit agreement was leaked to the Yellowhead Institute from one of the Wet'suwet'en band councils. And in it, there's all of these stipulations around what the band can say publicly or not about their agreement with Coastal GasLink, the pipeline company that aimed to construct this natural gas pipeline through their lands. And what is important to draw out here too is that it's not just public law, it's also how private law mechanisms are being used in order to turn Indigenous rights, turn Indigenous law into a private law matter so that it's a contract that can be negotiated confidentially without anyone finding out. So it's really a downloading of provincial and federal obligations to First Nations based on their agreements through treaties or based on their non-treaties and the rights they have there. It downloads those negotiations to private companies like Coastal GasLink to determine the extent and the nature of those rights, which is really terrifying, but more and more prevalent. There's hundreds of IBAs across the country. I just want to make one last point, which is about the need to talk about racial capitalism and to understand that these conflicts of law are not only about territorial competing claims for these lands. They're also about fundamental racial hierarchies in this country that are created through the need to exploit the land and to harm and remove and permit violence against Indigenous women, girls, trans and two-spirit people. In order to create regimes of accumulation, the state needs to create hierarchies of difference in order to justify that violence. And those hierarchies of difference are as old as the country itself in terms of how Indigenous people, Indigenous women in particular, have been used as as fodder for the sort of rolling through Indigenous territories. This is a quote from Lee Miracle, where she writes in Bobby Lee, Indian Rebel, "My experience just wouldn't let me accept these wooden arguments about proletarian unity and revolution." And what she's talking about is that just having an anti-capitalist perspective on ecological degradation or poverty or any of the myriad issues that are surely born of capitalism without understanding the importance of colonization and the role it plays in our relationship with each other and in the accumulation of wealth in our society. So she writes, "Look, do you want me to believe that those guys I had so much trouble with who went over to the reserve looking for Indian women, raping and plundering, are going to make a revolution to free us all from oppression? You got to be kidding." She's talking about the really important work fundamentally we need to do to address the kind of racial hierarchies, patriarchal attitudes in society that also underpin colonization, where you can't really untangle these systems from one another. And that was really the message that the women who sat at our table and collaborated on Land Back sent very strongly to us, is don't separate these issues. Once you start to separate the issues, you're going to start to come up with solutions that create more problems. So I just wanted to end on that note and leave it there and open things up for discussion.
Yeah, so I'm gonna, in a moment, invite people in our audience to ask questions, but I have one myself just to get the ball rolling. And I'm gonna start it with I thought an amazing quote from the Land Back report, which just gets everything in a neat little tangle. So the quote is, "Land theft is currently driven by an unsustainable, undemocratic and fatal rush towards mass extinction through extraction, development and capitalist imperatives. It's further enabled by a racist erasure of Indigenous law and jurisdiction. This fatal rush functions as a kind of malware released into our ecological system. Indigenous legal orders embody critical knowledge that can relink society to a healthy balance within the natural world. This change must begin on the ground. Canada ceding real jurisdiction to Indigenous peoples for this transformation to happen." And so I think the second last question is often something that's floated in ecological law circles. So, there's often statements about looking to Indigenous law and Indigenous philosophies for ideas about how to ground legal orders in the workings of the earth and make it, and sort of to inspire a different way of thinking about law. But I rarely hear the next step, which is your last sentence. The way to do this is to step back and allow Indigenous peoples to have jurisdiction. So I just wanted to get both of your comments on that about, what role is there for non-Indigenous peoples to take up the ideas of Indigenous law, or is the role simply just to step back and let Indigenous people manage manage their territories and implement their law.
Go ahead, Rayanna.
Okay, so the approach that we take is, like I said, encouraging and building capacity in community. So we work with people we call community guides, and these are people who are hired by their nation to do this revitalization work and work really closely with the re-lawyer that is, working on that file. So, like, I think the role of re-lawyers, we're a mixture of Indigenous and settler lawyers, is to really, be clear about like our roles. So like, I can only speak for myself really, but like as an Anishinaabe person, I'm still Indigenous and I work with Indigenous nations, but I always make it really like clear to myself that I'm here in solidarity with that nation, and whatever they're trying to do, my job is to support in bringing that vision to life. So like I can use my skills and my education to look in the Canadian legal context for tools that will support their, revitalization work. So I think it very much depends on the skills that you have, but also being clear on like, just making it clear to yourself about what your role is and how you want to do that work with, that nation. I'm not sure if that answered. Maybe I'll let Shiri add on.
I feel the same way, but I'm not Indigenous, so I'm not ever in a community where I can speak on behalf of the community. But I think that seems very complex for people as well. I think the idea that when you speak, you're clear that you're speaking from your own perspective. And like Rayanna said, you're coming with a certain set of skills and you're asking the community, are these skills useful? And the community has the agency to decide for themselves. I think there's some sort of like knee-jerk reaction that if there's a white person in a community, they're being exploitative. And sometimes they are. I mean, a lot of the sort of paid professional class is in a sense, can you hear me? But there's also a sort of disrespect sometimes in that assumption, because it assumes the community doesn't have the agency to decide who they want to work with and who they trust. And I think that's the community's decision. And in terms of our role, being as humble and learning to listen and really understanding listening as a skill that you have to learn. And sometimes you have to unlearn a lot of academic assumptions going into a community and learning to listen. That's really important. And also I think speaking then as a non-Indigenous person, I think that other non-Indigenous people often really want to experience indigeneity or their idea of indigeneity. Yeah. And I think that's a problem sometimes, because I think, of course going to ceremonies is incredible. And of course, listening to songs makes you cry and grounds you in such a deep way, listening to the drum. Of course, those things fill your soul. But I think it's important to cultivate a discipline where we understand our role as being as far away from the fire as we need to be. And so we're not going to be as warm, we're not going to be as close, but that closeness, we need to reserve as much space around the fire for Indigenous people themselves who have experienced, as Rayanna said, a lot of loss. And really think about, am I taking someone else's space here? And if I'm taking someone else's space by necessity right now, what am I doing to mentor an Indigenous youth? What resources am I putting towards Indigenous youth organizations? Really being conscientious about what our power is in terms of the resources we have to open up a space for other people to occupy it who need it more than us.
Yeah, there was a few things that came up for me too, but yeah, basically like our process in our partnerships, often like it's very fluid, but the first part is obviously making trust and building that relationship, right? When at the same time we're doing our homework and looking at those stories and discussing those stories. So sometimes trust might be built sooner rather than later. Sometimes trust is built later rather than sooner. It's very depending on the context and our relationship with, you know, the representatives doing that work, and just understanding and recognizing that there's, yeah, exactly that, learning and unlearning to do. When I first started working at West Coast, I co-wrote this blog with a lawyer, and she's a settler. So it was from the perspective of a settler and Indigenous lawyers on what allyship means. It would be on our West Coast environmental blog, but yeah, just like having these discussions and looking internally and self-teaching too. So there's so much resources and books and podcasts and, you know, all these things that we can learn from to be better individuals, to be, so then that we're able to come to our work in a better way and honor people's agency, trauma, loss, but also their resilience, brilliance, and love for their land.
So we have one question in the chat, if you guys want to sort of have a look at it while I read it out. So it's from Etienne. Hi, Etienne. He says, thank you both for wonderful presentations. The question is, the new Impact Assessment Act mandates that quote unquote Indigenous knowledge must be taken into account in impact assessment processes. Does that include Indigenous law, or could it or should it? And more generally, how do you assess meaningful dialogue, early engagement between promoter and Indigenous communities, and eventually co-management as a way to reconcile Canadian sovereignty and Indigenous title?
So I think, you know, the Indigenous knowledge does encapsulate Indigenous law. I think it's very dependent on that particular nation, on where they are in the process of revitalization. So some are further along than others. Some haven't lost as much as others. So, you know, it could be done like that revitalization work can sometimes be done, you know, quicker, although it does take a lot of time. So I think, you know, that Indigenous knowledge does definitely include Indigenous law, but it's like up to how that nation defines their laws. So if that's like we use the term at West Coast Indigenous law instrument. So they might have, you know, an act or a written legal instrument that describes their process. So I know my nation does with any work that's done with development. We have Manitoua Kianakanagewan law. So that's like how to treat our land properly when in, you know, engaging with us when trying to develop on our land, for example. That's what guides us in those processes, right? So it's very dependent, but of course, every Indigenous nation has knowledge and law, but whether it's accessible or not is, yeah, dependent. And then moving on, how do you assess meaningful dialogue? So I think, just kind of unpacking what those concepts mean. Hold on a second, I need to close my window.
The joys of Zooming at home.
I had to mute my kid screaming if he could have a Rice Krispie square.
So I feel like that's a difficult question to answer off the top, but the way we view dialogue and engaging with, you know, stakeholders or Indigenous knowledge holders is right at the get-go, even before plans are established. So, for example, like, you know, if it's a proponent or if it's the government who have plans to do this or that, then we would encourage them to have discussions with those nations first before, you know, planning begins. So to encourage that meaningful dialogue has to happen before, during, and after. So yeah, that's all I'll say for now. I'm not sure if I answered it, but.
I can speak to this too. I'm going to copy and paste a link here, which is about an article that just came out. Headline: New Indigenous Advisory Committee has no power over Canada's energy projects. So it's a National Observer article that looks at whether or not the Indigenous Advisory Committee, that's now part of, integrated into the environmental assessment process, or the impact assessment process as it's called now, had any impact. And what they find is that it hasn't had much of an influence, which, I mean, there were signs of that since the final decision making never came down to the Indigenous Advisory Committee. It would always be held with the minister. So now it looks like there's starting to be enough sort of data to really find out. But I have heard good things, and I don't know if West Coast Environmental Law has been involved in these, but I have heard good things about the option to do regional assessments through the act. I know that I think the Secwepemc for Ajax Mine did a regional assessment, and were able to, and decided through the regional assessment that they would reject the project, and were successful. And that other communities, I know in the Ring of Fire in Northern Ontario, are also attempting, there's a sort of process to be verified to be able to undertake your own regional assessment process, but I've heard that it's a possible, people are hoping that it's a possible way that Indigenous people could have a final say through that process, or a sort of small off-ramp within the process that gives them more control.
Yeah, and we do have a lawyer who does that work. His name is Gavin. But I also just wanted to add on to that, you know, so we facilitate dialogue between, you know, government officials and First Nation leaders in strategizing with implementing, you know, their own laws, for example. And like I said, the trauma-informed approach and preparing for these meetings and these dialogues, what questions do we want to ask? So I'm hearing a lot more within the legal context with Indigenous peoples, and coming to the table with Crown governments, but it's basically beginning with I agree to disagree. So it's you believe that you have Crown sovereignty, we believe we have sovereignty, let's agree to disagree and move on to the solution, the problems we need to face and the solutions that we need to plan and organize. So and then allowing those things to be set on the table, that's for another day. We could still work together today and solve the problems that we are facing today together, without, solving these massive issues throughout Canada today. You know what I mean? So there's different approaches and ways to, facilitate that dialogue, to encourage, just open dialogue, because often if that's the beginning of a meeting talking about, Indigenous sovereignty and Canadian sovereignty, the meeting's not going to get anywhere, so yeah, it's a lot of thinking and a lot of heart work, we call it, that goes into preparing for, negotiations and meetings like that.
So I have a question. It's in a private chat, so you can't see it, but it's about the way in which colonization skewed the role of gender in decision-making processes. So the question is, do you see a role for feminist policy, e.g. intersectionality-based analysis or gender-based analysis, to play in supporting the rebalancing of power and decision-making?
I mean, 100%. So I think the biggest example for me is the water work that I do. So I have worked with water laws for the past, I guess, 5 years now. But really, it's the women in my culture who are the water carriers. It's us who speak on behalf of the water. And it's us who pray and lead in ceremony that honors the water. And, so just thinking of how my people are organized, there's specific roles for, femme people, there's specific roles for masculine people, and then they're, you know, those kind of like intersect as well with two-spirit people. So those who are, you know, LGBTQ, who have particular roles within our societies as well. So I've definitely witnessed a huge resurgence in the last, you know, 7 years with people in my generation really talking about these roles, and understanding ourselves, and, you know, and it's not specific to like the sex of the person. Like, so I said femme and masculine. I didn't say female and male, because somebody might be identifying more femme than masculine, or, you know, something like that. So, you know, gender roles, gender discussion is ongoing dialogue within the RELAW program, within our co-learning program as well. So yeah, it's interesting.
Shiri, did you want to address that, or shall I? Are there any further questions? Geoff.
Yeah, before I do sort of wrap up, I just wanted to, you know, Kirsten and I and others here today, and of course not here today, have been working on this idea of ecological law, which is still a pretty new concept. It's not environmental law. In fact, we have tried to do quite a bit of work to contrast it to environmental law and to other areas of contemporary law. So it's in a process of creation and co-creation. And the webinar that's going to follow this is going to be a discussion about race and ecological law, as I explained. And the way that I'm thinking about that is that it's got two elements. And one is about how ecological law can address systemic racism and related questions of justice at all scales. So I guess I would expand that here to say, part of this is, the question would be, how can ecological law address legacies of colonialism and colonization and oppression that underline legal systems like we have in Canada? And then the second part is, how can we make sure that ecological law is co-created? And we also have tried to emphasize the need for co-creation, for being expansive and pluralistic about holders of knowledge that are relevant in that process. So how can we make sure that ecological law is co-created within an inclusive community and space with awareness of systemic barriers based on race or indigenous status or historical legacies of colonialism? And also to develop a more commitment backed up with action to overcome those barriers. So I'd just like to pose that question to you, which I hope to build on the next webinar. But in light of the discussion we've had today about those two elements, one more on the substantive side, what can actually ecological law include that addresses these justice issues? And second, how can we create an inclusive space and community for developing ecological law?
I don't know, maybe I'll just say something quickly. I'm not sure I took in the full depth of your question. I sort of want to see it written down so I can think about it, because I think there's a lot in there. One is about what is the practice of ecological law, and one is about how can ecological law be conceptualized in an intersectional way. Maybe I'm not re-articulating that properly. If I am, then I just wanted to say one thing about it, which was, if ecological law is going to not reproduce colonization and sort of its attendant forms of racialization, I think ecological law needs to be pluralized. So I don't know what Rayanna thinks about this, but when I think about Indigenous law, I think about Nisga'a law, Métis law, Inuit law, Anishinaabe law, carrier law, all the different national legal orders, which have some relationship in terms of being not instrumental and positivist like colonial law, but they also have very different sources of law because they're very interconnected with the places where people were placed and the histories of creation and co-relationship with non-humans in those places. And so I would just think that maybe a starting point is to think about Indigenous ecological legal orders rather than ecological law as one thing.
I would just add, I think too, that, you know, how can ecological law, your question, Geoff, how can ecological law, you know, confront the history of colonialism? And one, you know, one avenue was in Shiri's presentation when she said, well, look at the roots of Canadian law in this political economy and how it was driven by resource extraction. And I would take us even further back, like, where did that come from? You know, my ancestors, and it's a long time ago, but they were driven from the land as well. And the trauma is much older and probably buried and gotten over in some way. But, you know, it's sort of ironic that we called Indigenous peoples nomadic, but Europeans became the most nomadic and disconnected from territory, the people most disconnected from territory. And so, you know, we have, I think, suffered the trauma of disconnecting ourselves from our ancestral territories, and perhaps starting to recognize that the violence that we meted out to other people, where does that come from? Where have we learnt that? And sort of, I don't know, do a bit of psychoanalysis, something like that, to deal with the roots of where that drive comes from, and deal with it in ourselves.
And I'll just add a little bit too. So there's a lot to, so it sounds like you need to be clear about what, you know, it is to yourself, but also how it'll be perceived into the world, or how it'll be shared into the world. So with the RELAW program, we have, you know, a communications plan on, like, with legal education about Indigenous law, and, you know, taking up opportunities like this to share with different audiences about our work. So, you know, there's a lot that goes into our communications. We like to call it like the legal education. And, you know, we're an environmental NGO, so it's like we have a particular role within the NGO world to be, we have the ability to be, you know, trailblazers for how to do things in a good way. So yeah, it's just like, how do you want to be viewed from the world as well? And how do you want to get those messages across to the world is just as important as understanding what your role is within that work.
So we've got about 5 minutes left, and I've got 2 questions. Perhaps I'm going to ask them both at once. I can't see Rain's question. Do you want to say it out loud, or do you want Geoff to read it?
Yeah, I can go ahead and ask my question.
Okay.
Yes, so my question might be geared more specifically towards Rayanna. I've actually worked with Pacific Rim National Park on the west coast of Vancouver Island, and I was a little bit aware of the War of the Woods that happened on Mears Island and the notion of culturally modified trees being used as a source of evidence in the lands claims dispute of Mears Island. And I was just wondering if you had any examples of other notions or concepts or evidence that has been used and recognized by federal courts in a court of law in a lands claims dispute similar to that one.
Okay, so I'll also just jump in with the second question, and perhaps we can respond to them at the same time, just in the interest of time. So the second question is from Vivian, who says, hi Vivian, she's really interested in methodologies to decolonize the Indigenous instruments developed through internal conversations in the community, how to dream beyond the written acts and texts that sometimes appear to simply mirror Western technologies and outcomes. She's supporting the Mbara Chami communities in Colombia, currently reviewing their consent protocol, and the issue of form has come up. There seems to be a certain stuckness in using the Western format. Any tips?
Okay, I'll try first. So in response to the first question, immediately my mind went to the Supreme Court of Canada's Delgamuukw decision. So that was the first Supreme Court of Canada decision that recognized that, you know, there are Indigenous law and legal orders throughout Canada, specifically with the Wet'suwet'en, and recognizing that hereditary system that they hold. And we see those two legal traditions coming to, you know, face to face today, Canadian law and Indigenous law in with the Coastal GasLink pipeline. And then Canada's, you know, basically only consulting with the bans when the Indian Act bans, when their own court acknowledged that it's the hereditary system who are the title holders. So that's, you know, one thing to look into that will, you know, provide a gateway and doorway into more examples. As for, you know, the decolonizing Indigenous law instruments, yes, this is like definitely something that comes up often. So, you know, there is a balance. We understand that Canadian, like Crown governments and, you know, proponents understand written instruments, right? So like, this is the language that they understand. So that's the biggest reason why nations choose to go the written instrument route. But there have been, you know, RELA partners who've developed a song that goes with, for example, their constitution. So it's able to reach out to their community. So, you know, there's different ways that like it could be decolonized in some ways, or, you know, that deal with those matters. But of course, like there's still, like, that's our reality, right? So yeah, open to more ideas and always open to continued learning and different tools that are available. So that's the biggest thing.
I don't know if I have time. Maybe I'll just say 20 seconds to Vivian's question, because this came up for Barrier Lake, a community that I work with, an Algonquin community in Quebec. They had to codify their Onakanagewan, their sacred constitution, in order to be recognized as a band that had a customary governance system instead of an Indian Act governance system. And the elders were really upset about that, because there's something in the oral tradition and the way that it's passed that is part of the governance system. And so that problem of codification is quite deep and quite a heavy decision for a lot of communities as well. Eventually they did it, but they were very clear about what they would commit on paper and the parts of the tradition that had to remain oral.
Could I just add one more thing? So I talked with one of my elders about this before I began my job here, because like we're working with written stories and we're mostly oral societies. So what he said, his name is Fred Kelly, he said, like, as long as there are concepts in the language that guide that work and knowledge holders that are guiding that work, then like, then I believe that it's fine. So like how I explained to you what that concept in Nintinawe took in my language, like I explained that to you. So like a lot of the Indigenous law instruments have the people's language in it, and then it's explained. So we always encourage, you know, language use in the Indigenous law instruments. And often like the Indigenous nations already know that that's going to happen. So.
So we're right at 5 o'clock. I'm going to pass to Geoff to wrap up, but I just wanted to say my huge thanks to Rayanna and Shiri. I know this time of year there's a lot going on and you guys are very busy, and I really appreciate you coming and sharing your work with us. It was great.
Yeah, and I second that appreciation. We were so fortunate to have you with us, and this is a kind of conversation that can go on much longer than an hour and a half. But luckily we had that time. Again, everybody, I invite you to join us again on October 21st, when we'll have a somewhat related conversation dealing with race and ecological law. This webinar will be recorded and pasted on the ELGA website. So if you want to refer to back to it or look at it and send it to others who weren't able to attend, it will be there in the coming days. Thank you all so much for your participation today. Take care.
Take care. Bye.